This case doesn't start messy, it arrives messy. The judge immediately flags that the file has blown up, which is courtroom shorthand for too many moving parts and not enough control. Multiple parties, missing attorneys, and self-represented individuals create a volatile setup before any facts are even tested.
That the court has been informed that Mr. Worley is here today and he's representing Mr. Quintero. Ms. Bailey's former counsel withdrew in February and she has not rehired anyone. This is pro se. The court will note that the ad litem is present, Ms. Swartz. The attorney for Mr. Quintero is present, Mr. Worley. The court will further note that my understanding is that there is a intervener in this matter also at this time, one of the grandparents, but I don't see that they're being represented by counsel. They're here on a pro se petition. Is that correct? Is my understanding correct on that, Ms. Wexler?
Yes, they do not have attorneys, Your Honor.
Although, right. Your Honor, I don't believe that they are the grandparents.
One is the grandparent and one is not the grandparent, and we do not believe they have standing, Your Honor.
Correct.
Okay. All right, then. Well, I'm going to get to that eventually, but anyway, but I will note that I did get a chance to see that they had pleadings on this file. Again, this file has gotten kind of blown up on us. But anyway, everyone is here that needs to be here at this time. So I'm going to start with the state and ask the state to tell the court what the state's requesting we do here today, whether or not this is going to be a final hearing or has it gotten so complicated this can't be it. And then I'll listen. I'll have then I'll have Mr. Worley make an opening on behalf of his client, tell the court what he wants to establish here today. And then I'll have Ms. Swartz make an opening at this time. Also, here's the deal, folks. Mr. Lapham, I think that's showing up as Lapham. I'm thinking you're one of the interveners. I don't let non-lawyers make opening statements. I will, however, go ahead and at the end of this hearing, if the end of the opening statements, if I feel that you need to make an opening statement based on what the lawyers have asking for, then I will let you make an opening statement. But right now, I just want to try to figure out what I want to do here today and how long this might take. So at this time, I'll start with the state and then, like I said, go to Mr. Worley and then to Ms. Swartz. Thank you.
Yes, Your Honor. The state believes that we have an agreement on this case, but first, let the record reflect that I have what has been previously marked for identification as State's Exhibit A, which is the DNA test report in this case. I can share screen to tender it to everyone, and I ask that it be admitted into evidence at this time. May I share screen, Your Honor?
Yes, you may.
And no objection from me, Judge.
No objection.
All right, until I find that Mr. Lapham is not, pleadings are not, or he doesn't have standing or anyone else other than the parties already here. Ms. Bailey, I'll start with you and then I'm going to go to Mr. Lapham. Ms. Bailey, is there any legal reason I should not let this DNA test in evidence at this time, ma'am?
Excuse me, can you repeat that? My phone is very staticky.
Okay, is there any reason I should allow the DNA test in your case into evidence at this time, ma'am?
No.
All right, Mr. Lapham, I know you're not a lawyer, but do you have an objection at this time, sir?
No, Your Honor, I have no objection.
All right, State's A's admitted. Go ahead and pull that back up a little bit, please, while I get it on the record. And then scroll down to the very bottom again. Thank you. All right, yeah, that's good enough. That's good enough. All right, kids. Okay, so State A is admitted, and State A shows that the DNA test that was performed in this case on Mr. Quintero and the child in this matter. Go ahead and scroll down a little bit, please, Ms. Bailey. I'm sorry, Ms. Betzer, wrong beat. All right, it shows that the probability of paternity is 99.999999996, which is well within the guidelines of 99.99. The court will also find that Mr. Quintero is the biological father of the child in this matter. And Ms. Bailey, Ms. Baxter, you may go ahead and proceed with your opening statement. Thank you.
Yes, Your Honor. I'll stop sharing, Your Honor. Okay. I object to the interveners. I do not believe they have standing, but I believe between Mr. Quintero, Ms. Bailey, the ad litem, and Mr. Quintero's attorney, I believe we have an agreement for JMC, SPO, all distances, but Mr. Quintero establishes a primary residence with no geographic restriction, And then Miss Bailey pays child support to Mr. Quintero at the amount of $542 per month starting May the 1st, 2026, and medical support at $100 per month starting May the 1st, 2026. And we are not asking for retroactive child support because Mr. Quintero has had the child for only approximately 2 weeks. The temporary order did have non-disclosure, Your Honor, so I figured that that would be continued. And the other items I do not have any position on. And that's it, Your Honor.
All right, then, Mr. Worley.
Judge, I mean, to be short, I concur with the state in the position she set forth as what I believe is an agreement between the parents and the state in this case.
All right, thank you. And Ms. Swartz?
Thank you, Your Honor. I believe that it will be important to have a method of contact information, especially with the non-disclosure and exchanges in a public place. I believe on the transportation issue that because respondent mother moved out of Texas to Georgia, she should be responsible for transportation for visitation. Ultimately, obviously, that's up to the court, but that definitely needs to be decided, I think, before these parents are trying to work out visitation. I will say that this is a different situation that I wasn't informed of, that the child had moved within the last 2 weeks to be with respondent father. It's my understanding that he is still living with his mother. She, and I believe I see him nodding there. And I believe that the child is very comfortable with paternal grandmother. There was a CPS case prior, and she was placed with paternal grandmother. And this child she can't even speak yet, and she has the cadence of someone. She's very serious and believes strongly in eye contact. So she's got a lot to say as well. So I think that going back with her paternal grandmother clearly made quite an impression on her. So I think that is a very appropriate and safe place for her to be with father and paternal grandmother. And I believe that if that were to change and if it were an unsafe situation, paternal grandmother would make sure to get involved.
All right. All right, everybody, let's get some testimony from everyone, confirm this information. I didn't know the state of Georgia had come into play on this one. I've been on the phone with them all weekend anyway. A friend of mine had a birthday this weekend in Atlanta. So, so Georgia's on my mind also. All right, everybody, let's go. Oh, boy, bad pun. Apologies for that. Anyway, I'm going to go ahead and get everybody who's going to testify at this time. And Mr. Latham, right now, I'm just go ahead and have the principals testify.
The DNet evidence lands like a formality, not a fight. No objections, no hesitation, just instant acceptance. That silence is louder than any argument. It confirms this issue was settled long before the hearing. And we need your testimony. I'll let you know in just a moment. But this time I'll ask both Mr. Quintero, Ms. Quintero, please unmute yourself, Ms. Bailey. If you have video, go ahead and turn it on. If you can't, don't worry about it at this point. But both of you need to, and just to be on the safe side, Mr. Latham, and anybody else who's intervening in this matter, you also go ahead and raise your right hand. I'm going to swear everybody in. So at this time, everybody raise your right hand. Each of you solemnly swear or affirm your testimony you're going to give here today is the truth, the whole truth, and nothing but the truth will help you.
Yes, sir. Yes, sir.
Ms. Bailey?
My camera is not coming on. I'm pressing it and it's not coming on.
All right, as long as I can hear you, that'll work, ma'am. Do you so swear to tell the truth, ma'am?
Yes.
All right, everybody's officially under oath. I'm going to go ahead and let the state call you as witnesses. The lawyers have the opportunity to ask questions, and then we'll go ahead and confirm the agreement. Thank you.
Yes, thank you.
Probably, if I may interrupt, sir. Ms. Coleman and I are in the petition. She's here also. I don't know if you can see her. We're using the same.
She's the maternal grandmother that was spoken of. Yes, sir. But right now, like I said, there's an objection also at this time that y'all may not have standing. but I'm going to go ahead and hear all the testimony, and then I'll make a ruling at the end on that. All right. I know that doesn't make any sense to lay people, but what the standing means, you have to have the right to intervene in the lawsuit. And Texas is real strict about that as far as third parties and even grandparents are concerned. But let me go ahead and hear the testimony. I think everybody's in agreement, and we'll take it from there. All right, Ms.
Thank you.
Wexler?
Yes, Your Honor. Shall I start?
Yes, I'll call you. Yeah, go ahead and call your first witness, please.
Yes, Your Honor. I'll call Tavion Bailey. Miss Bailey,
Yes,
what is your name?
Tavian Bailey.
What is the name of the child in this case?
Serenity Royal Smith Quintero.
How old is she?
1.
Who does she live with?
Her father,
Who is her father?
Carlos Quintero.
When did you move in with Mr. Quintero?
2 weeks ago.
What state do you live in, Miss Bailey?
Atlanta, Georgia.
Does Georgia have income tax?
I believe we do, but it's not like it's state income tax, I think.
Is it approximately 5.19%?
Yes, ma'am. Roughly around there.
Do you have a job?
Yes, I do.
How much do you make per month?
Roughly around 3,500.
How many other children do you have?
Just 2. Just my daughter and my son.
Your son, where does he live?
He's with his father currently also.
Do you pay child support for him?
No, not at all.
How old is he?
4 weeks.
Do you have access to private medical insurance for Serenity?
No, ma'am.
I'll pass a witness, Your Honor.
All right, Mr. Worley.
No questions.
All right. Especially okay, I'll let Ms. Swartz carry the water on this. Well, as Cousin Vinny would say, you're going to have to hold the water. So go ahead. I'll let you ask the questions as far as custody is concerned. Ms. Swartz, thank you. But it's your witness. Thank you, ma'am.
Thank you, Your Honor. Ms. Bailey, are you requesting, what form of visitation are you requesting?
Well, the form of visitation I'm requesting, maybe like I get to see her 3 times out of the week, but like every month or so, or every other month, if I could do that.
Okay,
So,
here's the thing. Let me intervene here. Here's the deal, ma'am. Y'all live great distances apart. I'm assuming Mr. Quintero is still here in Texas. There's a standard visitation package in the state of Texas for visitation. You're entitled to one long distance. You're entitled to at least 1 week in a month. You're entitled to 2 days in the summer. You're entitled to every spring break. You're entitled to certain holidays. But the responsibility of transportation for that child would fall on you, because you're the one that left Texas. He's still here. I'm still here. The child is here. So that would fall on you. I do set up FaceTime and things like that weekly, but obviously with long distance visitation, Georgia's not that far away, but even that far away, you're probably realistically, ma'am, weekends are just not practical, because it's 3 days. It's 3 days.
Yeah, true.
So the holidays will be the summer, the 42 days in the summer, either Thanksgiving or Christmas usually each year, and then spring break, because you get every spring break. Those are the big 3 most people use on these long distance circumstances. And again, and the package also sets up how y'all have to provide transportation. This baby's only 1 year old, so this is going to, and the transportation is going to have to be you or initially coming, either flying in to pick the child up or driving in. Once the child reaches a certain age, the package includes setting up transportation through the airports and how that's to be handled ahead of time. But again, you would have to set that up as far as getting airline tickets, getting to the dad, and he would be ordered to turn the child over to take the child to the appropriate airport. And so long as the child is a certain age, you'll have to pay for someone to fly with her, or you would have to come and do that yourself. And then after certain age, you could pay for somebody to take to escort her once she's old enough to be escorted by the airlines themselves. But based on a child this young, your package is going to be 3 different setups. You doing it initially, then you baby, and still doing it, but allowing someone to do it for via the airline, or you coming in and do it yourself via airline. So, and again, ma'am, because of the distances, I would order in my order that you give Dad at least 30 days advance notice that you're going to do your visitation for Christmas. You're going to do you're going to do your visitation for Thanksgiving, or you're going to do your visitation for spring break, or you're going to do your 42 days in the summer. So all this can be taken care of and making sure everybody's on the same page as far as pick up and drop off. So that's the way that normally works, ma'am. Do you have any objections to me throwing or doing the standard possession order with that in there, or do you have something else in mind? And again, I always she's only one. I order FaceTime twice a week on Sundays and Wednesdays.
Okay.
Y'all can agree to anything else. But at 1 year old, I make it usually 30 minutes. But if you're gonna have to put on a clown suit and dance around to keep a 1 year old for 30 minutes, okay?
Yeah.
So, based on all that, now, is there something different that you're asking the court to do? Thank you.
The agreement presented isn't balanced, it's structured. The father gets primary residence with no geographic restriction, which is the most valuable position in custody cases. The mother, meanwhile, accepts child support obligations and gives up leverage without pushing back.
No, I think we could come to an agreement, and I believe that this could be our final hearing.
Okay. Well, y'all can agree to anything as far as visitation, but once it gets court order, if you can't come to agreement about the holidays or summer, the order controls. Understood?
Understood.
All right. You may proceed, Ms. Schwartz. Thank you.
Thank you, Your Honor. And you're agreeing to have Mr. Quintero designate the primary residence of the child, meaning choose where the child lives?
Yes.
Okay. And there's some rights and duties that we need to talk about. Have you all talked about that at any point?
I mean, not really, but
okay. Are you wanting, so basically, if your daughter is needing to go to a different doctor, or if you're choosing what school she needs to go to, are you wanting to be consulted before that decision is made?
yes.
Okay. And are you okay with that instead of both of you deciding together, since he's going to be the one with your child?
Yes.
Okay. Okay. So, and that would be for non-emergency big decisions. Does that make sense?
Yes, ma'am.
Okay. But you would still be a managing conservator. Is that appropriate for you?
Yes, ma'am.
Okay. And do you believe that that's in your daughter's best interest?
Can you repeat that?
Yeah. Do you believe that it's what's best for your daughter, that it's what's in her best interest?
Yes, I do believe so.
Okay. And you believe that Mr. Quintero having the exclusive right to choose where she lives, do you believe that's in your daughter's best interest as well?
Yes and no, but
it's got to be yes.
Yes.
You can't go in. This is all in the pool circumstance. You got to go all the way in. So one of you has to have the right to decide domicile.
Yes, it's okay then. Yes.
Right,
okay. And are you in agreement with providing a method of contact that will be consistent, especially since your address is going to be you're not disclosing your address?
Ms. Schwartz, I'm going to order both of them to go on Applos. I know it's $8 a month now for everybody, but yeah, they both have the money to do it. So I'm going to order a parenting app, ma'am, and all communications will be through that parenting app, including FaceTime, texting, everything. That way, everybody can keep track of each other. And if something needs to come in court later on, this parenting app makes great looking evidence. All right, they generate the documentation that's necessary for a court of law. So that's what I'm going to do going forward. So you may proceed, Ms. Schwartz.
Thank you, Your Honor. And you're in agreement with paying child support at this time since the child is in the custody of Mr. Quintero?
Yes, ma'am.
Okay. I will pass the witness.
All right, thank you very much. I'm gonna go ahead and let the state call the next witness at this time. Thank you.
Your Honor, I forgot one question. May I ask Ms. Bailey?
Go right ahead.
Ms. Bailey, are you self-employed?
Yes.
That's all, Your Honor.
All right, thank you. Any other questions of this witness, Mr. Worley?
No.
All right, any other questions at this time, Ms. Swartz?
No, Your Honor.
All right, you can call your next witness, Ms. Bexler. Thank you.
Excuse me,
yes,
can
Your
I go
Honor.
take a break I gotta go use the bathroom really quick.
All right,
Sorry.
everybody, 5-minute break, 10-minute break. All right, we're off the record for a second. Thank you.
Yes, Your Honor.
We'll be right back on. Everybody go take their break. I'm gonna sip my coffee, then I'll have to worry about restroom breaks later. Thank you.
Oh, that's it, Bethany. Yeah, go on.
Yeah. All right, it's a break, Mr.
Of all of Serenity's needs there when she's living with you,
Yes, sir.
is she happy?
Yes, she is. She's very healthy and happy.
Okay. And if you could have Leonard Lapham and your mother, if they are there near you, have them put their device on mute so it won't do this echo.
It says my microphone's muted.
Can you turn it down a little bit?
Yeah, let me just turn the volume way there. Okay.
Okay.
All right. So do you believe that it is in Serenity's best interest that she continue living primarily with you?
Correct.
And I think this has already been covered, but you presently reside under the same roof with your mother. Is that correct?
Correct.
And your mother's name is what?
Ruby A. Cobbin.
And does Ruby Cobbin help you take care of Serenity?
Yes.
Okay. I pass the witness, Your Honor.
All right, thank you very much. Ms. Swartz?
Does anyone else live in the home?
No.
Okay. And did you agree with consulting with Miss Bailey before making any big decisions regarding your daughter?
That's fine. I can understand. She's my child's mother.
Okay, and you understand that you would do that through the app that the judge is going to order you to use?
Is it the same one that we've been using to video chat each other for the visits?
Y'all been using App Close, sir?
I'm sorry, say that again, sir.
Using App Close already. I do that. It used to be free back in the day when we first started this case, but now it costs a little bit. So
I do believe it's the same one. That's the one I was asking.
Yeah, that's what I'm gonna continue all the order, and I think I got to pay $8 a month now, or $8.99.
That's more than fine.
So, yeah. Okay, thank you.
Yes, sir.
And there was a previous CPS case, correct?
Yes.
And your mother was placement during that case. Is that fair to say?
Well, can you break down the definition?
Your daughter lived with your mother during that time, right?
Yes, she lived with us.
Okay. And CPS had checked that home and approved it?
Yes, they actually came to my house 2 times.
Okay. Okay. Do you agree with everything that Miss Bailey agreed to earlier?
Yes.
Do you believe that this agreement is in your daughter's best interest?
Yes.
I'll pass the witness, Your Honor.
The guardian ad litem doesn't dominate the conversation, but she doesn't need to. Her role is influence, not volume. By emphasizing the child's comfort with the father and grandmother, she reinforces stability without attacking the mother directly.
All right, then. Mr. Latham, I'm looking at going ahead and saying, I hear anything that sounds like you have a judicial interest in this matter. Looks like the parents have come to an agreement, and I'm thinking that you're probably in agreement with that because again, the child's coming to the household where I think you also reside alone with the grandmother. So I'm going to go ahead and at this time, I'm going to find that I'm looking to go ahead and find it that this is in the child's best interest that I approve the agreed to order at this time, and that the fact that that the interveners do not have what's called legal standing to intervene at this time, and the order is only going to deal with the parents, the child, as by agreement that was testified to here today. So at this time, sir, that's what I'm looking at. Do you have any questions about that, or do you something else you want to, or is there something you want to tell the court that why you think you might have legal standing for the court to include you in this order? Or do you think you no longer want to be included in this order, sir?
Were you speaking to me, Your Honor?
Yes, sir.
I'm sorry. Yes, sir. Miss Ruby Coben and I are trying to get standing in this matter because a number of things have come to light where Serenity is actually possibly in danger by being around Ms. Bailey.
Okay, here's the deal, man. Here's the deal, sir. You have to have what's called legal standing. I haven't had a chance to go over your pleadings, but the state's objected to you having legal standing as far as coming into this case. So at this time, I'm looking at going ahead and ordering, approving the agreement. So you tell this court why you feel that you have legal standing in this thing. I know you're not a lawyer, sir, but you're asking a lawyer thing. So and again, it doesn't have anything to do with the facts. It has to do why you feel like you have legal standing, or why do you know you have legal standing to intervene in this lawsuit, sir?
Yes, sir. Under Texas Family Code, a non-relative can have standing to intervene if they've had substantial contact with a child and if they have information which is in the child's best interest that they would like to present to the court.
All right, sir. And what do you allege your substantial contact is, sir?
Serenity lived with me from possibly October 17th, I believe it was. Would live with me with her mother for about 3 weeks at a time, and they would go back to Temple for a week and then back. So for about 4 months, I had substantial contact. I fed her, clothed her, changed diapers, so on and so forth. And under the Texas Supreme Court has ruled that some people a non-relative can be considered a psychological parent.
Anything else, sir?
That's all, sir.
All right, thank you. Any other anyone who wants to make a statement for or against? I know the state's already said that they feel like that there's not enough there. I'll let the Mr. Worley, do you have any input on this whatsoever, sir?
Well, Judge, I mean, my input would be that Ruby Cobbin, who is an intervener, I acknowledge that she is the paternal grandmother, but I do believe that any concerns or issues the court may have would be satisfied given the fact that my client, Carlos Quintero, actually lives with Ruby Cobbin. And so, and he's already acknowledged in his testimony that they both obviously participate in providing care to this little girl. So, I don't have any position. I mean, I don't think that there really is any emergency necessity that the court would find or have with placing this child in the environment where she's being raised primarily by her father with the assistance of the paternal grandmother. As far as Mr. Lapham is concerned, I'm not really familiar fully with all of the issues he's claiming that would afford him standing, other than looking at the petition. That's all I have, Judge.
All right, thank you very much. Mr. Lyden.
Your Honor, I do know who Mr. Lapham is, so just to clear a couple things up as well, which I think will make this a little bit more easier. Mr. Lapham is the mother's former paramour, and as stated, the other intervener is paternal grandmother. It doesn't sound like Mr. Lapham lives in the home, But I don't believe either have standing. It sounds like their main concern is with respondent mother having unsupervised access. When I visited mother in the home, I did not see an emergency situation. Primary is with respondent father, but that's the nature of their, I guess, emergency request would be regarding that unsupervised time with respondent mother. I did visit that home. I did speak with respondent mother, and I did not note any concerns, which is all I can say to that. But hopefully that's also helpful to have that background.
All right. All right, anything, I'll go ahead and ask for closing at this time from the parties. I'm going to find, I don't feel that there's enough for the purposes of Mr. Latham. I'm going to go ahead and find that I don't feel that they're standing at this time. I thought it seems that I have an agreed to order that seems to be in this child's best interest. I'm going to go ahead and proceed at this point. Obviously, you have the right to do anything you wish as far as your order is concerned, or your appellate or de novo rights are concerned at this time, sir. But this time, I'm going to go ahead and make the finding as to the two interveners and proceed on the agreed to order between the parties at this time. So that's what I'm looking at doing. So I'm gonna go ahead and listen for closing statements at this time from the attorneys and take it from there. So at this time, anything in closing, Ms. Bexler?
Yes, Your Honor. Just to reiterate, $542 per month starting May the 1st for child support of 2026, and then $100 for the medical support. And Mr. Quintero establishes the domicile. And no retroactive, Your Honor. All
right, then. Is there anything old on that? Again, I had a chance to go through this whole file again because it's got kind of thick on me. I'm thinking there was an original temporary child support order. Is there zero judgment on that at this point or anything?
Wait, is you talking to us?
I'm sorry, ma'am?
Is you talking to us?
I'm talking to Ms. Bexler.
Oh.
Before testimony even unfolds, the judge locks the direction of the case. He frames everything as confirmation, not discovery. That's a subtle but powerful shift. It tells everyone in the room that the goal isn't to argue, it's to finalize.
Yes, Your Honor. In the temporary order, there was no child support ordered yet.
Okay, good enough. I just want to make sure that wasn't a problem. All right, thank you very much, Ms. Bexler. Mr. Worley, closing, sir.
Judge, I really don't have any closing other than asking you to follow the agreement that the parents have entered into in this case that Ms. Wexler has laid out for the court. Thank you, Judge.
All right, then, and Ms. Swartz?
And Your Honor, just to add in that exchanges be in a public place, communication be by app close, that all major decisions be made by Mr. Quintero after consulting or attempting to consult through app close with respondent mother. Those are my only other requests.
All right, I'm going to grant all those requests, and I'm going to make part of the order that upon any exchanges that obviously I'm going to make everybody. I always put the 30-day requirement in there, but if that exchange request is made, Mr. Quintero, you within that 30 days, and you set it, and it's then set up, sir. You need to find the office. Right now, where do you live, sir? What city?
Was you talking to me? I'm sorry.
Yes.
San Antonio, Texas.
All right, then, and that's where your grandmother lived. I mean, that's where you live with your mother there, sir?
Yes, sir.
All right, then. I'm going to make the exchange at the police station or sheriff's department station that is closest to your residence going forward, sir. So when you get that 30-day notice, you need to tell mom, okay, this is the, we're going to make the exchange at the Bexar County Sheriff's Department Annex, so-and-so address. and that you do that by app close also. And if you move or you change residence, but you'll always do it whatever that law enforcement agency that's closest to your home is. And I mean the county one, either the sheriff's department or your local police department. We won't throw in the Texas Department of Public Safety. We'll keep the state police out of this, okay?
Okay. Can I ask 2 questions?
I'll let you do that in just a moment, sir. All right,
Yes,
then.
sir.
All right, then. Well, I guess this is a good time to ask 2 questions then, sir. What are your questions, sir?
Um, my mom wants to know, can she speak?
No, sir.
Okay. And the second one, how do I go, like, say if my child's mother, she comes and gets my child and she
No,
doesn't
sir,
bring
sir,
my,
stop. I don't answer what if questions, okay, sir? You need to run those scenarios by your lawyer, and he can tell you what you may or may not be able to do, okay? You have a
okay.
lawyer. So, but yeah, what if Mama wins the lottery this weekend and comes back in with $50 million behind her? You know, what if? All right, it's probably not going to happen. But again, we can't make orders based on something that might or might not happen, sir. But you can ask your lawyer about any what if scenarios you have. All right.
Yes, sir.
All right. Anything else, sir?
Nope, that's it.
All right then. All right, I'm gonna go ahead, like I said, I'm gonna name you both joint management service. I'm gonna give you the right to decide domicile, sir. I am gonna go ahead and restrict that right to somewhere in the state of Texas. You can live anywhere you want, but so long as it's in Texas, if you need to change your jurisdictions, you need to come tell me about it. I'm gonna approve all of the aspects of this order. I'm going to approve the agreed to child support, the agreed to cash medical. I'm going to go ahead and include the visitation package. This child is now under the age of 3. The standard visitation package will not kick in to the age of 3. You two can agree on anything else up until then. And if y'all do the weekends, the spring break, the summer, all that's included at spring break and the in the summer and the holidays are all included, but mom has to give you again 30 days advance notice that she's going to do the pickup and drop off, and we'll make the pickup and drop off at the police station or sheriff's department close to you. However, for summer, instead of it being for 42 days until the child reaches the age of 3 or above, I'm limiting the summer visitation to 30 days. So I'm not going to do it with the full 42 until the child's over the age of 3. But again, mom's got to provide the transportation. Mom's got to give you 30 days notice. If you don't get anything 30 days notice in advance, you then you don't have to worry about that. Y'all can agree to anything you want, but if you don't get the notices as per the order, then it has to be by agreement going forward. As far as I'm going to order FaceTime visits with the child twice a week. I do that at 6 p.m. on Sundays and 6 p.m. on Wednesdays. When 60 Minutes comes on Sundays, our Central Time, which means, ma'am, that's 5 p.m. Georgia time. So you'll call over here at 5 p.m. and I'm sorry, that's going to be 7 p.m. Georgia time. I went the wrong direction on you. So it's 6 p.m. Central Time are the visitation packages for FaceTime, and that's every Wednesday and every Sunday. And ma'am, you also have to give notice at least 48 hours in advance that you're going to do your FaceTime that upcoming weekend. That way everybody can get ready, because again, getting a 1-year-old or 2-year-old or 3-year-old ready to go on anything is a little bit of a chore. So I'm going to go ahead and order that you give them advance notice of at least 48 hours in advance that I'm going to, you can do it 3 days, 4 days in advance, but hey, I'm going to do my FaceTime this Sunday. I'm going to do my FaceTime this Wednesday. And that way the child can be available. If you don't, then it automatically means that you have to do it by agreement. But other than that, it's automatically set up. But you have to give them at least 48 hours advance notice that you're going to do it. I'm going to go ahead and again give you the visitation package as stated earlier. And I'm going to go ahead and at this time, I'm going to go ahead and waive court costs as to both parties at this point. So is there anything else I need to specifically rule on at this time, Ms. Bexler?
Court costs.
I waived it, ma'am. I just did.
Family violence finding, none, right, Your Honor?
No one requested me to do so. I don't think so. No, I'm not making one. No, ma'am.
And then the non-disclosure, though, is that to continue from the temporary order?
The mother's testimony sounds cooperative, but it steadily reduces her position. She confirms the child is already living with the father, admits her move out of state, and accepts financial responsibility. Each answer reinforces the father's stability advantage.
I didn't hear any testimony on that. The attorney's requesting that.
Well,
I'm
during
not,
the
Judge.
temporary order, Your Honor, you ordered that the addresses not be disclosed.
All right. All right. They have to keep each other informed of addresses, but it does not have to be written into the order. Okay. But both parties are to keep it. Both parties are to keep each other fully informed of all address changes and addresses and phone numbers.
Yes, sir.
All right.
So-
Anything else?
Do not put a non-disclosure in there, Your Honor. Is that?
You can put a non-disclosure is just for the court order, ma'am. But I'm ordering the contact information does not have to be in the order. In fact, I don't want it in the order. But they have to keep each other informed of their addresses and phone numbers through app close going forward until further order in court.
Yes, sir.
Your Honor, may I make a brief statement for the record?
Yes, ma'am.
I feel that it's important to say as attorney ad litem that Mr. Lapham and Mr. Quintero's mother both have the contact information for me, and I was not sent anything that would lead to any concerns for me to investigate apart from the investigations that I undertook based on what I did receive. But I've been on this case for quite a while now and had spoken with both of them. So I wanted that on the record as part of my role to investigate the child's well-being.
Yes, ma'am. Thank you. Duly noted, ma'am. Thank you. Now, don't worry, I was getting ready to go through all the lawyers again, so I've been done this to work. Anything else at this point, Ms. Bexler?
Your Honor, I had pulled up the address potentially of the sheriff's office that's closest to Mr. Quintero's home. I believe that 200 Kamal Street. Is that close to you, Mr. Quintero?
Hold on, I can look right now. Give me one
That would
second.
be great. That would be the easiest, I think.
The closest one to me is Balcony Heights
Police department,
Police Department.
right up the street.
And what police department is that, sir?
Balcony Heights Police Department.
Department.
I'm sorry, say that again.
Is it San Antonio Police Department? Is it suburbs? What's the police department's name, sir?
Oh, I'm sorry. What's the street up here again?
Frederick,
No, the police. What is it called?
Dare County?
No, the police.
What city you live in, sir? You in, sir? That's gonna be your police department.
Yeah, I'm sorry. It's Balconies.
Balcones?
Yes, sir.
Balcony Heights.
Do they have their own separate police department?
Everybody want to confirm that?
That's at 3,300 Hillcrest.
That's the closest one. That's up on 524 tickets right up.
Hmm.
You want to go downtown or something?
Mr. Quintero, is it what's the address again, Ms. Bexler?
3,300 Hillcrest Drive.
Is that the one, sir?
Yes, correct.
All right, that's the balcony.
I got it.
Okay.
Yes.
All right, thank you. Anything else, Ms. Bexler?
No, Your Honor, I think I'm good.
All right, I think I already asked you again, but again, Mr. Worley, anything else, sir? Anything as far as rulings concerned, you think I need?
No, Judge.
All right, Ms. Schwartz.
No, Your Honor, thank you.
All right, everybody, I'm going to let the state prepare that, circulate the order among the attorneys and the pro se litigant, and get that signed off on. If there's anything other clarification needed, please let me know. And again, ma'am, Ms. Bailey, that FaceTime you get on the weekends, on Sundays and Wednesdays, that's also going to be through App Close. They have that FaceTime function on that, and the texting function. Everything is through App Close. Understood, ma'am?
Understood.
All right, everybody. I'll let the order get prepared, and if there's a further clarification needed, just ask anyone that needs to clarify something, file the appropriate motion. I'll give everybody 3 days notice, but judge is going to be out for the next month, so that hearing might not be for a while. Okay, so I'm going to be out for the month of May, and I'll be back in June. So thank y'all all very much. Everybody be safe, and we're officially off the record. Thank you.
Excuse me.
Thank you.
Thank you, Your Honor.
Thank you, Judge.
Yes, sir, Mr. Yes, sir.
I'm sorry. Can I ask 2 more questions, if you don't mind?
Any questions you have, caller, you'll ask to me directly,
Yes,
not to the judge, not to Judge Nelson.
Okay.
Okay.
Thank you.
If y'all go back to the breakout rooms, that'd be
Sure.
great, so I can start the order.
And Your Honor, I'm just waiting for that day that Travis County gets a little less busy so that I can get back on your appointment list. I love getting to see you. I love it.
Thank you very much. Yeah, well, I've had a couple of Williamson County cases that I could have used y'all, okay, but I had to send somebody else, okay?
Okay, I think I might be able to convince my staff. If it's people in Travis County or Williamson County, I think that's close enough that I can make a visit happen. We'll see.
All right. Yeah, because now Williamson is Travis, so we're not. They're just too big now, also. So
That's what I figured. I don't think they come up that often for you.
Anyway, thank you, ma'am.
Thank you. Bye.
Bye. All right. I see Mr. Welch is in here, and Mr. Gwynn's in here, and okay, and so. Okay, everybody.
Your Honor, I don't have a hearing, but Mr. Gwynn does.
All right, Mr. Gwynn, what do you have, sir?
All righty, Judge. I've got.
Should be getting an invite to your breakout room, sir. Look for it again. Thank you. The testimony you're going to give this court today is the truth, the whole truth, and nothing but the truth to help you.
Yes, sir.
Yes, sir. All right, you're both officially under oath. I'll go ahead and let the state call your witnesses. You can turn off your video. That usually helps with bandwidth if you're only on your cellular, and we'll let the state take it from there. Thank you. And Belinda, if you need to, send me a copy by email of the state's information, and I'll try to print it out on my printer. Okay? Thank you.
The father takes the opposite approach: minimal, controlled, and effective. He doesn't over-explain or defend. He simply confirms stability, housing, support from his mother, and the child's well-being. That restraint builds credibility.
And on that note, the state would like to submit State's Exhibit A, which is a DNA testing report. If you would like, I can screen share.
Screen for that one. Like I said, we're having trouble with those that print out. Thank you.
Understood, Judge.
All right, this is the DNA paternity analysis for the alleged father in this matter. Is that correct? And the which child, please?
That's correct. So, as the court can see, it's for the alleged father, Zachary Ty, and the child, Zadie Ty.
Okay, the court will note that this is a DNA paternity report that shows that Mr. Ty cannot be excluded as a biological father of the child. It's well within the guidelines of 99.99. It's in fact, it's 99.9999996. And so the court will so find that that Mr. Ty is the biological father of this child. Thank you very much, and you can stop sharing. And like I said, if we can't get it printed out on her printer, I'll get it printed out on mine and admit that into evidence. If there's no objection to that evidence being admitted at this time, Ms. LaGoria, you have any objection, ma'am?
No, sir.
Mr. Harry, do you have any objection?
No, sir.
All right, so found. You may proceed with your next. You may proceed, Mr. Gwynn.
State would like to also submit State's Exhibit B, which is going to be the incarceration information of the father.
All right, go ahead and share that at this time, please. All right, the court will note that the state's showing the information concerning the Mr. Ty and his current circumstances of being incarcerated as States B. Any objection to the court allowing this into evidence at this time, Ms. Longoria?
No, sir.
Mr. Herring?
No, sir.
All right, States B is admitted. You can stop sharing at this point, Mr. Go ahead. The court will note that it does show his sentencing information and his release date, not for being about another 5 years out, another 4 or 5 years out. You may proceed, sir. Thank you.
Thank you. State would like to call Rachel Longoria.
Ma'am, state your full name for the record.
Rachel Longoria. Junior. Yeah.
How many children are we here on, Ms. Longoria?
Just 2.
And what are their names and ages?
Zachary Ty, and he's 5, and then Zadie Ty, and she's about to turn 3 this next month.
All right. And you understand that Mr. Ty is incarcerated?
Yes, sir.
How are those children receiving medical coverage?
They're covered under me, through my employer, and then they're also covered through Medicaid right now.
Okay. And you understand that due to Mr. Ty's incarceration, child and medical support for the time being is going to be set for 0 until further court order or modification?
Yes, sir.
Okay. And you are not at this time requesting retroactive support?
No, sir.
Okay, no further questions of this witness at this time, Judge.
All right, then. I'll go ahead and call your next witness, please. Thank you.
Already State would like to call Isaiah Herring.
Yes, sir.
State your full name for the record.
Dan McCarran.
And Mr. Herring, you are in agreement that you were not the father of Zadie?
Sir.
All right. No further questions of this witness at this time.
All right, then, Mr. Gwynn, I was looking for the acknowledgement of paternity that shows Mr. Herring signed off on the necessary documentation that he wasn't the father of that child and that Mr. Ty was, but I don't see it in the court file. It's not attached to the pleadings. It may have been State's Exhibit C. This is the AOP, acknowledgement of paternity, and it shows the information that both Mr. Herring and Ms. Longoria have signed off on, showing that Mr. Herring is not the biological father of the second child in this matter. Is there any legal reason this should not come into evidence at this time, Ms. Longoria?
No, sir.
How about you, Mr. Herring?
No, sir.
All right, the court will duly note for the record that properly executed denial of paternity and acknowledged paternity that was signed off on by all 3 parties is appropriate, and I will also find that Mr. Herring is not the biological father of the child that's covered by this AOP. The court's going to go ahead and grant the request of the state. The state requesting, the mom requesting joint MC or sole MC on this one right now?
Sole MC, I am of the understanding, if you look at the offense history in that TDCJ document,
Right.
One of the charges is for assault of a family member.
All right, the court will duly note, and at this time, based on that, ma'am, I'm gonna go ahead and name you sole managing conservator of these children with all rights to decide domicile. I'm not gonna restrict those rights. You can live anywhere you want. I'm gonna order 0 child support and 0 cash medical based on the fact that the father is incarcerated and will be incarcerated for at least appears to be for the next 3 to 4 years. I'm going to go ahead and give you all the rights under sole managed conservatorship. I'm going to name him a possessory conservator, but I'm not going to give him any rights under possessory conservatorship. I'm going to hold those in abatement till he comes back and asks this court or my successor to order him to have rights based on his circumstances at that time. Because we don't know what his job's going to look like. We don't know what kind of terms and conditions he might be out on any type of parole. So at this time, I find it's in the best interest of the child that I do not find or give him rights under possessory conservatorship. I'm going to also go ahead and find that Mr. Herring is not the biological father of either of these children, and as far as this case is concerned, he is dismissed. I'll waive court costs of everyone due to either incarceration or being an innocent bystander in your part, Mr. Herring, and the mom because she's the one that the state did this on behalf of the child for based on her circumstances. So is there anything else I need to specifically rule on, Mr. Gwynn, to cover this one?
At the sake of being redundant, he is not granted any access and possession rights until further order of the court.
He actually gets no rights whatsoever, obligations or rights under the possessory conservatorship until further order of this court.
And did the court have a specific ruling on non-disclosure?
Non-disclosure is granted until further order of the court.
The interveners attempt to disrupt the outcome, but the law shuts them down instantly. Their argument focuses on emotional involvement, time spent, care given, but the judge focuses on one thing: legal standing. Without it, none of their concerns matter in this courtroom. That's the harsh reality of family law. Structure outweighs sentiment. Once they're removed, the judge finalizes everything with precision. Primary control goes to the father, financial responsibility to the mother, and strict rules govern communication, visitation, and exchanges. This isn't just a custody order, it's a controlled system designed to prevent future conflict. Stability wins, and the court makes sure it stays that way.